At the Supreme Court, and I am once again joined by my colleagues Damien Schiff, Senior Attorney in our Environmental and Natural Resources Program. Did I get it right that time? And Oliver Dunford, a Senior Attorney in our Separation of Powers Program. First off, let's shout out PLF Supreme Court Show superfan George Lee for writing into the show, and we welcome all of our fans, and to everybody out there, please feel free to write in with your comments or thoughts on our show, how we can be better. We're wrapping up this year's term, but we'll be back for season 2, better and new and improved, and any suggestions that you have, we will do our best to incorporate. But this week we had 3 new opinions from the Supreme Court spanning issues in criminal law, civil law, bankruptcy, and we also want to talk about a few of the happenings at the Supreme Court, including tariffs, East Wing construction, and other things. And of course, we'll always end our Supreme Court show with a little trivia. Got a fun one for you today. But let's start with the opinions. 3 opinions. I think the only one that garnered any dissents was a case called FS Credit. Oliver, this is in your wheelhouse. What was this case about?
This case is about whether the Investment Company Act allowed or had an implied right of action for companies or funds to sue each other. The issue, again, is the Investment Company Act, which designates the SEC as the primary enforcer. The plaintiffs and defendants here were some petitioner funds. The petitioners managed...
Oliver, we are having trouble hearing you.
Can you hear me now?
Not really.
Good.
Can you try a different audio stream?
I can't at the moment. Why don't you go? Oh, it's better? Yes, better?
To our listeners, we apologize. We've gotten a new setup here on our streaming platform, and it seems to be wreaking havoc on our computers. But Oliver, give us another
better
go.
Now? Better now? Okay. All right, well, this case again involves whether the investment...
No, it's not working, buddy. We're going to start with Damien Schiff talking about the bankruptcy decision that came down. Damien, let's see if your audio is working.
Let's hope I don't go bankrupt on this bankruptcy. Is it coming through okay? Yes, well, and it's in a sense only tangentially bankruptcy related. The main focus of the opinion is this equitable doctrine of judicial estoppel. This is the concept which, as Justice Thomas's concurrence notes, is a doctrine that's fairly new in the law. It's the idea that if you're a litigant and you take a position in one case about, say, the meaning of the law or the nature of the facts, you can't, in a separate case, maintain an inconsistent position. And here that played out in the form of Mr. Keithley. He was he filed for bankruptcy. Shortly after submitting his petition for bankruptcy, which listed all of his assets at that time, he was in a car accident with a truck driven by an employee of the respondent here, Buddy Ayers Construction. And Mr. Keithley decided to sue the trucking company for personal injury damages. But when he did that, he failed to immediately amend his bankruptcy petition in his bankruptcy case to say that, oh, now I might actually have some additional money coming in because of this personal injury lawsuit I filed against this trucking company. So ultimately, the bankruptcy matter resolved itself with Mr. Keithley having to pay off his creditors within a certain number of years. But in the separate personal injury lawsuit that was filed in federal court in a different district, the trucking company was able to obtain the dismissal of Mr. Keithley's tort action on the ground that, well, in the bankruptcy case, he didn't list this lawsuit as an asset, which is functionally like saying, I don't have a claim. But now he's trying to sue us saying, oh, I do have a claim. That's inconsistent, and judicial estoppel prevents him from doing that. The district court of the Fifth Circuit agreed and tossed out his case. The Supreme Court, though, in a unanimous decision written by Justice Jackson, said no, the Fifth Circuit got it wrong. It's a very strange opinion in that the court assumes a lot of things in order to get to the answer. It assumes, to start off with, that the entire concept of judicial estoppel is a real concept that should apply in bankruptcy. And secondly, it also assumes that there is an exception to judicial estoppel when the person against whom it's advanced says that, well, I am being inconsistent for reasons of inadvertence or honest mistake. I'm not trying to game the system. So with those two assumptions, the court then said that the Fifth Circuit's interpretation of this inadvertence exception to judicial estoppel was too narrow. Too narrow in part because it didn't look at enough factors. The Supreme Court said you have to look at the totality of the circumstances as to whether somebody should be judicially estopped, whereas the Fifth Circuit was only looking at a few things. And secondly, perhaps more importantly, the court said that the particular things that the Fifth Circuit was looking at would basically swallow the exception, because the things that the Fifth Circuit looked at would be, well, did the bankruptcy debtor know about the facts? Well, presumably the bankruptcy debtor is always going to know about the facts, whether he has a claim in a personal injury case. And secondly, would he have a reason for not including it on his bankruptcy list of assets? Well, that's almost always the case as well, because theoretically, the fewer assets that you disclose in bankruptcy, the better off in a gamesmanship sense, the better off the bankrupt could be. So the court basically said the Fifth Circuit's interpretation of judicial estoppel is not generous enough to those against whom judicial estoppel is advanced.
So I remember when this case was argued, and I think the thing that stuck out to me was the party that was benefiting here, this third-party tortfeasor, really had absolutely nothing to do with the bankruptcy or with even, it's so like orthogonal to the actual bankruptcy proceeding. You like that word, Oliver? Orthogonal, huh? That's the Barry Weiss in me coming through. But they were sort of like, well, what's the word? They're like benefiting without having any reason to benefit from this. So maybe that's sort of underpinning the decision here, because it does, given all the caveats that you've listed, Damien, it seems like a very, not that precedential of an opinion, or an opinion that won't have that many implications going forward. What do you think about that?
Well, certainly, I mean, the Fifth and the Tenth Circuits had proceeded under this rather strict rule, which evidently did cause a lot of people in bankruptcy proceedings to lose what otherwise might be good claims. So in that sense, I mean, I'm sure there'll be some impact. But the point you raise, Mr. Thompson, is something that Justice Sotomayor, in her concurrence, highlights, that judicial estoppel seems just generally a poor fit in the bankruptcy context, because by definition, whenever it applies, it means that somebody's getting a windfall, and that the bankruptcy courts are in a better position to avoid prejudice to creditors while still preserving the fair rights of bankruptcy petitioners who might have personal injury claims. So,
if anything, the creditor that isn't able to collect from a successful tort claim, they should be able to like reopen the bankruptcy and then get some of the money from the tort claim. So that would seem like
exactly. Yeah, that's another point that was raised in the concurrence, that if Mr. Keithley can recover, then that means that he'll be able to pay off his creditors more quickly, which presumably you think the creditors would want. So, but what I found particularly interesting was Justice Thomas's concurrence, where he suggests that maybe this entire concept of judicial estoppel, at least at the federal level, should be abandoned. He makes a very good point too, that it's one thing to indulge in equitable estoppel, where you have the inconsistent positions, but the person being prejudiced is the person who is subject to both inconsistent positions.
Right.
That makes a little more sense, I think. In the judicial estoppel context, though, as well displayed in this case, the person who benefits from it is not the person who otherwise would have been prejudiced by the
Right.
change in position. So it is in some respects, as you say, it's a very narrow decision. In other respects, though, it does indicate perhaps the court's interest in revisiting aspects of this judicial estoppel concept generally.
Yeah. One maybe, yeah, I think that's maybe the point. Maybe this portends a future judicial estoppel case, and this was just the first toe in the water of the court visiting this issue. Maybe that's why the court wanted to take this. Otherwise, it seems like a sort of a one-off to me. But I guess my second question is a little bit more theoretical. I view the court as being more favorable to sort of hardline rules that don't allow for sort of judicial wishy-washy balancing tests. And that is frankly what the 10th and 5th Circuits had. They had a pretty bright line rule that was easy to apply, and the court says no to the bright line rule and instead imposes a sort of totality of the circumstances wishy-washy test. Does that sort of go against the mold of this court, do you think, or am I reading too much into that?
No, not at all. I mean, it is certainly surprising that one sees a majority opinion so prominently adopting a totality of the circumstances test with no criticism thereof. Even in Justice Thomas's concurrence, he doesn't object to that part of it. He just objects to the idea of judicial estoppel. Part of the problem here, if you want to call it a problem from the perspective of those who don't like tests with a lot of indeterminacy built into them, is that it is a doctrine of equity, and traditionally equity is something that is supposed to take into a lot of different factors. But perhaps this is also one reason why Justice Thomas is suggesting maybe we shouldn't even really entertain the concept. I think it's a fair point. I think it's also interesting, though, just from a court watcher perspective, that Justice Jackson wrote the opinion. It seems like she's getting a lot of these unanimous opinion assignments. She had the ERISA one, that rather obscure ERISA case a week or two ago, and I think she's had a couple of others. And I don't think that's particularly unusual for junior justice to have those types of assignments, but it's interesting to hear that would happen.
Yeah, it seems, she's the junior justice. You get the bottom of the barrel opinions probably, right?
And it doesn't involve the need to look at legislative history.
Zing! Oh, Oliver Dunford, you're back. Can you now tell us, or do you have more to say about bankruptcy? But if not, I would like to hear about that FS credit opinion.
Yeah, and the reason I said that is because it provides a segue. There is some dispute in this case, the FS credit opportunities, about legislative history. And the case involves, again, whether the Investment Company Act provides an implied right of action. And so this is a dispute between investors. The petitioners are funds who manage closed-end mutual funds, and those are funds that have a fixed number of shares. The respondents manage open-end funds, which allow for new shares. And what the respondents do is they purchase funds like the petitioners, and then they want to alter the investment strategies, or they want to convert those into open share funds. And so what the petitioners have done is they've incorporated in states that provide more protections for the shareholders. And so the petitioners were incorporated in Maryland, which places some limits on there. And the funds then adopted these protections that Maryland law provides, and the respondents sued under the Investment Company Act and said that those protections that the state law allowed were not permitted under federal law. And so again, the question is whether the respondents here could sue under this federal law. And what they pointed to was a provision of the federal law which says that a court may not deny rescission of contracts that violate the act at the instance of any one party, unless the court finds that doing so would be consistent with equity. There's equity again, and the act's goals. And what the court said is there is no provision for a private right of action here. And the reason is because the section I just quoted from in part talks about what the court can do, but it says nothing about what private parties are allowed to do. Part of the reason the court part of the reason supporting that conclusion, the court said, was that the Act does provide expressly for two private rights of action. And so again, when Congress wants to create a private right of action, it knows how to. It didn't do so here. That's the gist. But there is some back and forth between Amy Coney Barrett, who wrote the majority opinion, and the dissenting, or one of the dissenting justices, Justice Jackson, who relies heavily on legislative history. And by the way, this was a 6-3 opinion. Strangely enough, it was the usual, the conservative, liberal 6-3 decision here. Justice Kagan offered a dissent and said that her view of statutory history, legislative history, is somewhere in the middle. She thinks it can be helpful, but it's not dispositive the way that Justice Jackson at least got into it. And so she said, I join the dissent on the merits, but I don't join that part of the dissent that goes back and forth on all these things. But Amy Coney Barrett, ACB, has a few zingers in her opinion responding to Justice Jackson's, and one of them I want to get it here. It is: the dissent responds that it's hard to take this criticism seriously because all statutory interpretation seeks to discern Congress's intent, but rather than trying to unearth Congress's actual intent, courts look for objectified intent. Put differently, the judicial task is to read words, not minds. There's another good line in there somewhere. I can't find it. Here it is. The classic criticism of using legislative history is that it is the equivalent of entering a crowded cocktail party and looking over the heads of guests for one's friends, true to form around unwelcome guests. It turned a somewhat boring statutory interpretation question and had a few interesting back and forth.
Yeah, so at bottom, I mean, Oliver, as one who has many closed and open shares in his portfolio, I'm sure the merits of this decision was weighing heavily on your mind the last couple of months.
Yes, I was heading to the yacht to look more carefully at the opinion.
But at bottom, it's a question of whether so-called implied rights of action ought to be a thing. Here, there's a statute that says the government can bring actions to enforce these provisions, but there's nothing expressly saying that a private party wronged can sue to enforce these provisions. And the court says, well, it's Congress's purview to decide who gets to sue. They've said the government here, if they want to change that, they can allow private causes of action. And Justice Jackson's, I mean, if you're being charitable, I think the best view of hers is like, look, if they're violating the statute and the government's not doing anything, we need somebody to come in here and enforce the statute. The statute makes little sense if it can go violated, nobody can enforce it. I have some sympathy to that, but ultimately I would probably side with the majority here in that, as unjust as it may seem in our system, Congress gets to determine who gets to sue, and they have not made it clear in this case. Right,
and Barrett made an interesting point that one of the things Jackson points to is all these comments by some congressmen who said, well, the statute doesn't have this action, and the Supreme Court now applies a strict construction. And so Barrett says, well, if they know that, then why didn't they put in an express right of action into the statute? We don't know. There are all kinds of reasons why people in Congress have to make concessions and deals, and we don't know why they made them, but here's what the statute says. There's no right of action. And there was another case earlier this term, I think, I can't remember, but maybe it was anyway. But Thomas talked about it, I think, that in the 70s and early or years ago, the court was much more open to or allowing implied rights of action, and I think it was Scalia in an early somewhere said that those heady days are gone, where the court would divine these intentions from unclear statutes or anything. So it's consistent with the court's practice over the last 30, 40 years of not finding implied rights of action in congressional statutes.
Isn't it true here, though, also, Oliver, that the statute does authorize private causes of action for violations of other provisions?
That's right. There were two other expressly identified causes of action for private rights of action, and so they said if Congress knows how to do that if it wants to.
Yeah, this struck me as, sorry, Mr. Trump, I'm just going to say, it strikes me as one of those funny cases where you really see the advantage of somebody like Justice Barrett, who kind of comes from a professional textualist background. I mean, sort of her career was writing articles more or less consistent with a certain jurisprudence. So I think she's very familiar with the arguments for and against implied causes of action, legislative history, what have you. So yeah, I think that facility really comes through in her opinion. You can tell that this is something that she's addressed a lot about. What I found most interesting was Justice Kagan's one paragraph dissent, where she says, you know, I don't think legislative history is per se bad, but I do think that Justice Jackson is gone too far, so I'm not joining her part of her dissent. It kind of reflects to me where sometimes I feel like Justice Jackson is sort of trying to be the sort of anti-Scalia just for the sake of being the anti-Scalia, and just seems to be saying, oh well, if we recently jettisoned legislative history, then we're going to have to cite it in all of our cases, and we're going to have to heavily rely upon it and always, you know, try and reinvigorate it. And I think the more measured approach of Justice Kagan, even dissenting, seems to be a little more convincing.
Well, and Justice Sotomayor did not join Justice Kagan's one paragraph statement, but she agreed because she didn't join those parts of Justice Jackson's dissent that Justice Kagan also did not join. So it seems like Kagan is in this instance, as you say, completely on her own, which is fine. I mean, you know, she can make her points. We were all fans of Scalia's lone dissents for many years, and Justice Thomas's too. So I don't want to criticize her, but I don't know how persuasive she's being to your point.
Well, and she's being a true disciple of her Justice Breyer, who you know wrote the book on positivism and legislative intent and divining intent out of many things, and she clerked for him, and this could have been written by him, frankly.
Has she cited international law yet?
Or spaceports, like Justice Breyer wanted to do in my case. All right, there was a third case decided. Abu Amu versus United States. This was a case dealing with a statute that criminalized the falsification of documents. Pretty straightforward federal criminal statute. I remember this argument when it came up, and I found it interesting, and the decision came out exactly how we expected, but the decision also lays forth a little bit more of the facts that I didn't know from the argument that I want to relay. So what happened here is this Abu Amu was a Twitter employee and was being contacted by the Saudis to divulge like Twitter metadata on users to the Saudi government, and which he did, and then he quit Twitter and moved to Seattle and tried to continue working with the Saudis, and the feds caught up with him. And at his house in Seattle, they say, he's like, no, I didn't get this data from Twitter. I got it through my own sort of like research. And they're like, okay, show us that. So he runs upstairs, types up whatever he types up, and emails
it. It was a fake invoice.
A fake
money.
Yeah. Emails it to the feds who are downstairs, and they emails it to them in San Francisco, allegedly, because that's where their email inbox is apparently housed. And says, yeah, see, I emailed it to you. I'm all good. Of course, that didn't work. Shocker. The feds were able to discover that he just made it up in the 20 minutes that he was upstairs drafting it. And but what I found interesting is they I mean, presumably there were other underlying crimes that he was charged with, but the one pertinent to this case is this knowingly falsifying a document, USC 181519. And his argument is that he cannot be tried for that crime in San Francisco or the Northern District of California because he committed or allegedly committed all of the elements of that crime in the Western District of Washington in Seattle, where his home was. And the court, in a unanimous opinion written by, I believe, Kagan, says that's right. It rejects what the Ninth Circuit had held. The Ninth Circuit essentially said, well, there's some sort of judicial wishy-washiness in these statutes. You can't really say where everything happens. And Kagan's like, well, that may be true with a lot of statutes, but this one is pretty clear that there's only one element here. When did you create the document? And the moment he created that document was up in his bungalow in Seattle. And at that point, all of the elements of the crime had been committed, and ergo, he can only be tried in that district. Pretty straightforward case. I thought the facts were interesting. It brings up the Vicinage clause, which I mentioned this last time when we heard the argument, but it reminds me of my FedSoc advisor in law school, Brian Kalt, who wrote the article called "The Perfect Crime." And so I went and looked back at that and what are the elements of it. So it's the Sixth Amendment says you have to be tried in the district and the state in which the crime was committed, right? And so in this case, because the district was Washington, he had to be tried in Washington. But the Yellowstone National Park is a federal district that encompasses 3 states, or at least parts of 3 states. One of those parts of Yellowstone National Park is in Idaho, but the part in Idaho has no inhabitants. So you cannot seat a jury of Idaho residents, the state in which the crime was committed, Idaho. You cannot seat a jury in that district because there are no people that live there. So he hypothesizes that you could commit a crime in the Idaho portion of Yellowstone National Park, and given the Vicinage clause, if I'm pronouncing that right, I'm sure Damien will correct me, they could not constitutionally prosecute you for that crime because you couldn't seat a jury in the state and district in which the crime was committed. So he wrote that article to pressure Congress to change the jurisdiction of Yellowstone to allow for the District of Idaho to encompass that little section of the park, and Congress didn't change anything. So if anybody is interested in committing murder, I suggest the uninhabited portion of Yellowstone National Park in Idaho. I will say that I was reading a little bit more up on this, and it makes sense that they could still get you probably for conspiracy if that conspiracy happened outside of the park. So you better do it spontaneously when you go to this uninhabited portion of Yellowstone National Park in Idaho.
Well, then you'd have a defense for manslaughter at least or something.
Yeah, there you go. Go ahead.
Yeah, this Abu Amu guy, the guy worked for Twitter, was able to tell the Saudis who supposedly anonymous people were, and then thinks he can go upstairs and create an invoice and the FBI won't catch him. I just don't understand how he thinks he's going to get away with that.
Maybe he thought he was so smart that he could create a document that didn't have the metadata that he himself had found out to get to the Saudis.
Just unbelievable.
Yeah.
Oh, well.
Damien, any thoughts on Abu Amu or the Vicinage clause?
No, but interesting, since it was unanimous, what do you suppose the thinking was behind the assignment to Justice Kagan? I mean, it's not really an issue, I think, that...
It was her turn? I mean, it could be just that no one else had been assigned, and...
When was this argued? Abu Amu was in March, and so far in March we have had opinions from Sotomayor, Gorsuch, Kavanaugh, and Jackson. So it could have been Barrett or Alito or Thomas. and we have 2 opinions left, birthright citizenship and that Republican National Committee case. So sounds like she was the most natural one, unless she's going to would write the majority in the birthright citizenship case.
There's also the, I think, is that, maybe I'm wrong. I thought the case about the someone who stopped at the Mexican border case. Remember when they were?
Yep. Oh yeah. Yes, that one is all. There's 3 from March. Yep. So that's the other one.
So yeah, she might not be in the majority on those.
No.
Is
There
she
you
the
go.
senior? She's the senior of the progressives, though, right? Oh no,
No,
it's Sotomayor.
Sotomayor.
That's right. Okay, that's right.
Yep. But Sotomayor already wrote one. She
Yeah.
wrote Jules versus Andre Balez Properties. I don't
Speaking of
remember.
that, the ballot case. Did you see the New York Times had a editorial this week, criticizing California, and also correctly criticizing all the crazies who were saying that Spencer Pratt lost the primary because of fraud. But the editorial did criticize California for its ridiculous delay in counting ballots. And one of the things it says is the election day should be election day. All ballots should be in by then. And it said the question isn't whether there should be a deadline; it's whether the deadline is election day or 7 days later.
Yeah.
So interesting. But anyway, that's one of the opinions from March, that case in I forget, Chicago, where the
Yep.
or whatever it was, where the question is
No, I
whether
think
the
it's like
ballots,
Alabama or something, or Louisiana.
okay, whether the ballots can be counted if they were sent before election day but received after election day.
Yeah, that's still coming.
Yeah.
That's interesting that the Times. I did not see that. Send that
Yeah.
to me. I was gonna. Oh, I find it completely outrageous living in this state. Are we like in the backwoods that we can't count ballots? I mean,
Right.
what are you talking about? It's been, I don't know, how long has it been since the election happened? It's completely asinine.
Right.
Everywhere in the world they can count ballots. California, you find out like 30 days after the election. It's backwoods nonsense.
Which does, allow for these crazy theories to come out. They're unnecessary. It's not true, but
it invites the argument. It invites the
Right.
criticism. In California, I mean, it just doesn't make sense that you can't count the ballot.
doesn't
They say,
inspire
well, they're
confidence.
being mailed in. Well, then just count all the ones that we've had up until now. Give us that number, because that's got to be like 85% of them.
Yeah.
It's just
It's depressing how many things that government should be able to do, they just can't do competently anymore.
Well, we had a few other stories that are at least tangentially related to the court. One, dear to your heart, Oliver, is what's going on with tariffs these days.
Well, yes. In the case that we litigated, the IEEPA tariffs, the Court of International Trade had ordered the government to set up a system to repay people who had paid the IEEPA tariffs, which the Supreme Court said were illegal. The government was doing that, and then all of a sudden, a few weeks ago, it decided it was not going to do that. And now its argument, apparently, is that everyone who wants a refund of IEEPA tariffs has to bring his own lawsuit. Even though it had already apparently set up a system to provide refunds, it's now arguing that the orders that the courts had issued apply only to the plaintiffs in those cases. And I assume part of the argument is going to be that there can be no such thing as universal injunctions, and so all this other stuff. Problem, I think, is that the Court of International Trade is the only court that handles these kinds of disputes, and so the court has ordered the government to repay all refunds taken improperly through IEEPA. So we'll see where that goes. It seems like that'll get reversed or shot down. I forget exactly where it is. But
Where is our case at right now?
our case is being stayed. We did hear from one of our clients. They did receive so far a partial refund.
Oh, that's right.
So that's good. I assume that some of our other clients have also at least haven't been shot down yet because they are named in the lawsuit.
Yeah.
But the government is also trying to collect refunds elsewhere. It has apparently recently it's going under 301, which I forget exactly what that does. But before that, it had imposed tariffs under Section 122, which allows the president to impose tariffs for up to 150 days when there is an international balance of payments disequilibrium, which apparently was a thing before we had floating exchange rates, because one country could store all of its silver or something that we paid out. This is a problem that Adam Smith discussed many years ago. Again, it is no longer a problem, so it's not really a thing. The government lost, but the Federal Circuit has issued a stay enjoining, for now, the Court of International Trade's opinion ruling against the government. So it seems crazy, but again, it's another example of the government gets the benefits of the doubt that regular litigants do not get. In this case, it's in favor of Trump. Usually the courts have been bending over backwards to give injunctions when Trump is the defendant. Here, Trump is the well, I guess he's the defendant, but he is the move-on in this case, and he gets the benefit of the doubt here. So, very frustrating.
Well, in less frustrating news, Damien is excited that the UFC fight this weekend will go forward, and that the injunction sought to stop the fight from happening on the White House lawns, Damien, will go forward. So
I thought Damien was taking the kids to swim in the new reflecting pool.
I wasn't even aware that. I knew there was something regarding the White House construction, but it was specifically with respect to the UFC fight. I didn't know that.
Well, that was today's ruling. But Damien, do you know what UFC is?
Do I know what UFC is? It's the fighting stuff.
Fighting stuff. I'll give it to you. It is fighting. Yeah, but apparently that event is this weekend, and there was a suit by like some public integrity project or something like that said it could not go forward on the White House lawns, and a judge of the D.C. District Court rejected that attempt, and the fight will go forward.
Seems right. I mean, what's the is our guy fighting? Who's our sponsor? Remember our
Moicano? Money Moicano?
Yeah.
I don't think so. There is the lawsuit about the East Wing construction. It's brought by a different group trying to halt the construction. I think there's actually a 2-hour-long argument in the D.C. Circuit Court of Appeals this week, or maybe it was the Federal Circuit or D.C. Circuit, on whether that construction can be halted. Essentially, a historical preservation argument that Trump doesn't have the right to remodel the White House.
Hasn't that ship sailed? I mean, it's gone.
That I get from what I gather, that is the primary argument of the administration. That what are you going to stop now? We're like 70% way completed, but nevertheless, they heard argument for 2 hours on the issue. So there must be some legal issue that they think they still have.
This is not related at all, but do you know how Mayor Daley got rid of the lakefront airport in Chicago? He, in the middle of the night, he sent in bulldozers to chop up the runways with big X's, and it was totally illegal. But he did it, and everyone loved it. So I'm kind of want the mayor of Cleveland to do the same thing with Cleveland's lakefront airport.
Is that Jerry Springer, or who's the mayor of Cleveland?
Yeah, Cincinnati.
Oh.
He's the one, and he paid the prostitute with a check. Kind of like the guy in Seattle who thinks he can fool the FBI with a fake invoice. Unreal.
I also saw that Trump has asked the Supreme Court to intervene in his defamation, $300 billion defamation against CNN, 300 something. Chances the Supreme Court takes up that case, Damien?
Not great.
Well, you know what he could do? He could nationalize CNN and then strike a deal.
He's good at striking deals.
Yeah.
That's his thing.
Sounds legit.
All right. Anything else from this week in the Supreme Court, boys?
No, still waiting for the firing, whether the Trump can fire principal officers, birthright citizenship, some other big cases still out there.
Transgender athletes.
Yeah.
The election law case we were just talking about with the date of the election day.
What do we got here? End of the month? Is that usually the end of June? Is usually the?
Yeah. What we got? We got 1, 2, 3.
I think 20.
4, 5, 6, 7, about 20 cases. Pung, of course. Pung's still out there.
Pung, that's right. Our PLS case. And there's always with the emergency docket. It seems a little bit less active than it has been the last few years, but that keeps going all year round now. So
I am reticent to say that there were no districting issues this week, although I did see that the state of Washington changed their districts, and somebody sued saying that they were at least in part racially motivated. And the state of Washington asked the Supreme Court to take it, even though the claims had been rejected, because they want sort of, I guess, rubber stamping what they believe was legal. But I doubt at this point that the Supreme Court is going to take another one of these, but who knows? Yeah, all right. Give me a prediction of what decision do you expect next week, each of you?
I would expect the Monsanto Roundup preemption case.
That was the labeling out of Missouri case?
Yes.
Yeah. All right.
there's an Exxon case out there. Whether the Helms-Burton Act abrogates foreign sovereign immunity.
Oh, yeah.
Cases against Cuba. That seems like a less contentious decision, perhaps.
And I think we'll get Pung.
Ooh.
So Pung, the justices from March that have not written yet are Barrett, Alito, Thomas, and Roberts. So that bodes well for Pung.
Yeah, that's right.
All right, time for some trivia. And I did not. I have a presidential history trivia question for you today because I stumbled upon these two trivia questions and I thought they were too good not to share. All right, so the first, which president is the first president that was
Taft
born in an independent United States, so at least after the Declaration?
Ooh. I will say Andrew Jackson.
Okay. Mr. Schiff?
I'm going to say Millard Fillmore.
I'll give it to Oliver. It was Mr. Jackson's vice president, Martin Van Buren.
Oh, okay. Huh.
He was born in 1782, so before the war was over, but after we had declared independence.
So when was John Quincy Adams born?
He was born before that.
Yeah, well, obviously. But okay. Huh.
A related question. This isn't officially my second question. This is a related question. Who was the first president to be born in the United States of America? So after the Constitution took effect.
Millard Fillmore.
Taft.
Grant. Wrong. Grant. 1790. I'm talking about 8 years after Van Buren.
Oh, 17. Okay. I don't know.
James Polk.
Polk, yeah, Polk.
John Tyler.
John Tyler.
All right.
So there you go. Now my last presidential trivia question. This is what led me to look up the other two. Who is the only United States president whose first language was not English?
Oh.
John Quincy Adams.
Wrong.
First language, not English. Wow.
I thought he might have learned French or something when he was traveling around with his dad. Or Greek. Didn't he learn like Greek when he was 6 or something?
Probably.
He was ridiculous, yeah. Jefferson?
No.
Bill Buckley. He was never president.
Martin Van Buren.
Yes, it is Martin Van Buren. He grew up in a Dutch commune in like upper New York,
Wow.
and his first language was Dutch.
Huh.
So that's your Martin Van Buren history lesson for today.
Good.
Well, guys, thank you. Thank you to our listeners. Thank you to all of you who joined us. And
George Lee?
George, always a pleasure. Dan Lennington, our other super fan at Wisconsin Institute for Law and Liberty. And all of you who are joining us, we'll be back same time next week for more opinions, more happenings at the Supreme Court. Until then, I'll thank you from Damien Schiff, Oliver Dunford. Thank you guys for joining me, and we'll see you next week.